Let's take number 5, Annette Jackson and Ms. Quanada. I have Ms. Radecki there. I believe I saw Ms. Quanada log on. Are you with us?
Yes.
Okay. So I was just handed, while I was on my 1 o'clock docket, Ms. Quanada's, it says affidavit concerning court proceedings. And then I also got a declaration of Annette Jackson. Have the parties exchanged this information with each other, or am I the only one who has seen it?
So, Your Honor, I have received Ms. Kanada's declaration. The filing today, I attempted to send to Ms. Kanada on the email that I previously served her on, but it appears to be deactivated or no longer in service. I got a message that it bounced back. So I have unsuccessfully sent that to her, but in essence, it's just the mortgage statement that Ms. Jackson got from Freedom Mortgage stating that the balance was not paid off, in fact.
Okay.
I have that declaration and my new, if I can just give her my new email address, Microsoft had messed up my account, so they're all combined. So I'm not receiving any emails at all. But I have another email, tanya.quinata@yahoo.
And I'm not sure if you, the court would like to, call this in a little bit. I can email that to her right now. It's a pretty brief document, just so she has the opportunity to.
Let's do that. So I'm going to recall this case. I'll have Ms. Radecki email that document to you because it does have a mortgage statement with a current date. Looks like it claims to be from May 19, 2025, which would purport to show that it is not paid off. And that really is, as you know from our prior hearing, I'm not going to relitigate today my decision on the writ of ejectment. What I'm here to decide today only is the amount of bond, if any, that Ms. Jackson would need to post. And as you will recall, in order for me to make that decision, I wanted to know if Ms. Quanada had paid significant sums of money towards that home, in which case I would be more likely to set a bond than if not. So that's what we're going to decide today, Ms. Quanada. I know some of your filings reference some other issues, but solely in front of me today is what have you paid towards the house?
99A, which I have communication with Freedom Mortgage. And so I have that email, but I wasn't able to submit it because I just got it back. And they said that they wouldn't be able to send me a receipt of received until around the 6th of June.
Okay. What I'm going to have you do is check your email. Ms.
Okay.
is going to send you the statement from Ms. Jackson that includes the mortgage statement. And then I will recall this case and we'll make a decision. Okay.
Okay. And so I do have communication with them. I didn't submit it because I just received it because my email was messed up. So how do I go about like showing that we have communication about the payment?
What payment?
To Freedom Mortgage.
Why don't you forward it to Ms. Radecki?
Okay.
Okay.
I can do that.
All right.
Thank you, Your Honor. I'm ready, Your Honor.
Okay. Ms. Quanada, are you available for this case? Are you ready?
I believe so.
You believe so? Okay. I'm going to go ahead and handle this. So you've had a chance to review Ms. Jackson's declaration?
I have.
Okay. So I guess Ms. Radecki, I'll have you go first regarding any non-request for bond based on the facts that I asked for some more information on, and then I'll go to Ms. Quanada.
Okay. So, Your Honor, we are requesting no bond in conjunction with the writ for ejectment for the preliminary injunction. Reason being, Miss Quanada last week indicated to the court that she paid off the balance of the mortgage in excess of $400,000. She indicated that she did this action sometime the end of April 2025. My client, Annette Jackson, who's the owner of the property located at 124 Truth Street, she contacted Freedom Mortgage, who is the lender for the home, after the court hearing, and got a current balance as of May 19th, 2025. We have included that in her declaration, and she represents that that is an accurate depiction of the mortgage statement. The only change is that the loan number has been redacted, but otherwise it is a true copy of what Freedom Mortgage has given her. It indicates that there is an active balance of over $400,000 still. And this is information given straight from the lender, which obviously starkly contrasts what Ms. Quanada is telling the court last week and this week. So we would just request that the court take that into consideration, the fact that she has not paid off any balance. There's no proof to that. And in fact, the proof is to the contrary, the fact that there's still the full outstanding balance. There's a current amount due of $27,872.61. So we would just request that the court take that into consideration and not issue a bond for this matter, given that information.
Ms. Quanada, what would you like the court to know?
Well, just like Ms. Radetti said, the account number has changed. And the reason being the account number's changed is because it's mine now. I paid that off. It wasn't my fault that they lost the 1099-A to give me a receipt. So that's kind of what had happened. I had mailed it in. I mailed everything in together. They lost the 1099. After court that day, I called them and I asked them. They said they lost that portion of it, so they can't give me a receipt until they receive it. So I sent it to them. But if you notice, just like she said, they changed the account number because it's no longer under Miss Jackson. It's under my name.
So the difficulty I have is under for the statement with the date of May 19th, and it says payment due June 1, 2025. It still has Ellie Ezer and Annette Jackson on the mortgage statement, not you.
They probably do owe something, but I'm on a completely different account. And I don't think I should be held liable because they had misplaced it. They can't even give me a receipt for the payment because they misplaced that one form. So I did file with the IRS, the 1099-A. And if you want to, I mean, I don't know how that works. I've never did it before, but I can actually probably go online and print out the IRS form that they received it. So I'm not exactly sure where you want to go with this, but it's my son and myself. And I did everything that I was supposed to do. I went to the auditor's office. I asked them exactly what I was supposed to do. I brought them in and everything. They're the ones that handed me the quit deed claim and had me fill out all the forms correctly. And that's according to Cowlitz County rules. Is like whatever the auditor says is what they say. So I did exactly what they said. The house is now under my name also. And so I don't know, I'm not quite understanding why there's going to be a bond and all of this other stuff. I believe that this is a completely different matter. I think that it has nothing to do with the bond. The bond is actually supposed to be, hang on, I'm trying to go back within memory, but a bond is actually supposed to not transfer the house. A bond is supposed to be to secure the house or let me pull it up real quick. I'm sorry. Sorry about that. But the bond is actually supposed to be. You pull this up here. It doesn't. It's supposed to just. A bond's not supposed to substitute for rightful financial stakes. but it already establishes it. So I get that, but I've also put a lot of money in the house. I had to fix the furnace. There was a lot of stuff that was the I had to fix the walls, the doors, the doorknobs. I've had to change the locks. I mean, I do the maintenance on the house. I do all of the landscaping, and I do all of those things. And I've been there almost 3 years, and I'm with a minor child. So I'm not exactly sure how it is fair, more or less, to say that you're going to remove me and my son to put Miss Jackson in there when there hasn't even been anything prior to no notice except for an ejection. Oh, okay. Whoa. What's going on here? Because my belief was I just filed everything with Freedom Mortgage and the IRS. Okay, then that was it because it comes out of my trust. Cool. I never had to worry about that before because I paid off my cars like that, and that's just how it works. So I was super confused when they said they lost that form. So I don't think I should be held responsible or liable and be removed from my home because Freedom Mortgage has lost their portion of the 1099.
Ms. Radecki, anything further?
Just a few things, Your Honor. I mean, ultimately, the facts are pretty clear. We have Ms. Quanada and also let me correct myself from earlier. I said that the payment was made in April. I was mistaken. That's the date that the deed was filed. That Elazar Jackson, my client's ex-husband, conveyed the property to Miss Quanada, even though he clearly did not have legal title to the property. So we have that. We also have Miss Quanada stating that she was a tenant again, and I know we're not relitigating. This is just solely related to the bond, but just for the record, I want to clarify. She indicates that she was a tenant, and then also simultaneously indicates that she's paid off over $400,000, but miraculously, there's no proof of this anywhere. And in fact, like I said, my client contacted Freedom Mortgage directly as she is a party to the loan currently. There's been no modification or change of the loan number. The loan number has merely just been redacted by myself to submit to the court. And so we have no proof that she's made any sort of payment whatsoever. She has words, and she has a 1099-A. She sent the email that she sent me it appeared to be an email draft. There was no email address. And ultimately we have no proof that she's made any type of monetary payment whatsoever, and the proof states otherwise.
Can you forward me what she sent to you?
Yes.
And like I had said earlier, my email account with Outlook is really messed up. And so I am having to scroll up. And that was actually a scanned email that I printed out from the printer. So it's not even, that's all I have right now. But if you call Freedom Mortgage, the reason why there's two different account numbers is because one belongs to Miss Jackson and the other account number belongs to me. And so either way, there's no receipt. Is the government not a valid person to file a receipt with? I filed that with the IRS. So you're saying that my receipt with the 1099-A is false.
The 1099 I reviewed was handwritten. It was not prepared professionally by an organization.
It doesn't have to be. I actually have a trust that I go through all the time.
It goes to the credibility of what I'm reviewing in light of my concerns I already have about what has been told to different agencies as you applied for ownership of a home that the court had already issued an order on giving ownership and possession to Ms. Jackson. That's the point I'm making today. So I'm going to take a look at this email that you sent to Ms. Radecki.
And I apologize for nothing. What email should I send this to?
Send it to my last name, KARMYJ, at Cowlitz Kellett's wa.gov, I think.
Yeah.
Okay.
Okay, I just sent the email and I CC'd Miss Quanada in it as well.
All right, give me just a minute to get that in our email system. There we go. Okay. Resubmission, 1099 Dear Freedom Mortgage. Per my conversation, I understand that you need me to resubmit a 1099-A. Please find the duplicate copy attached for your records. Should there be anything more? This just looks like a screenshot.
That's what I said. All of my emails are stuck in Outlook, so I don't have anything, any communication logs or anything. I've been trying to communicate with Microsoft and Intel, and I have a whole bunch of logs that say basically I'm not able to get into my email, and so it's like kind of my answers. It's like I know it sounds like when it rains it pours, but it really did. And
So here's my ruling. I'm going to sign the order on preliminary injunction per my prior ruling last week. I don't find that there's any basis based on credible evidence that a preliminary injunction is not appropriate. I have concerns about the things that are being told to the court by Ms. Quanada, but I assume she has paid some amounts of money towards the home over the period of time she's been in it. So I am going to require a minimum bond of $5,000. That'll be the value of the bond. Pretty standard minimum amount that we would require. Again, I don't, if I had credible evidence that she had paid off a $400,000 mortgage, I would be requesting a much higher bond. I don't see that. What I have in front of me very specifically is a note as of May 19th, 2025, that over $400,000 is still due and owing on this home. So that is my finding. I have signed that order, and I think that concludes that case. Is there anything else the parties need from me today?
yeah, I just feel like the bond shouldn't take, because I am co-owner. And so, and it doesn't matter how you feel or anything like that, or anybody else feels. I filed it exactly the way Cowlitz County wanted me to file it. I don't know what's going on. I do know a little bit, but I don't try not to get into Eleazar and Annette Jackson's information or their dispute. I'm not part of that case. And so I believe that it should not be a substitute for rightful financial stakes. I feel like this is an abuse of discretion, that you're not allowing me to at least print out the IRS form that says that it's filed with them. I understand you gave me a week. I did not know that they had lost that or portion of and it's my fault. I didn't verify. Okay, I get that.
I'm basing my decision on the preliminary injunction and the bond amount based on the credible evidence in front of me currently. The case for the underlying possession of the property remains. So this is a preliminary injunction. You are certainly free to do two things. One, you have review rights of my decision today. You certainly can file for that. You have appeal rights, and you certainly have a right to prove your case when this specific action goes to finality. So I'm going to go ahead and conclude the hearing today, but you have several avenues you can pursue when and if you have additional information for the court. Okay, I'm going to go ahead and conclude this matter. Thank you both.
Your Honor.
And then